Viewers, welcome to the weekly episode of the Carbone Lawyers Law Lab podcast. My name's Tony Carbone. I'm the managing partner of Carbone Lawyers. With me, I've got John Carancis, senior partner and accredited specialist in workers' comp. Good day, John. How are you?
Hi, Tony. Hi, Stacey.
And Stacey Patsis, a young up-and-coming star in litigation at Carbone Lawyers. How are you, Stacey?
Hi, Tony. Hi, John. Thanks for having me.
Viewers, we've got a very interesting and important episode on transport accidents and car accidents in general. It's very important you listen to what we have to say, because what we do, John, is we basically cover off on what the injured people have to do to protect their interests, correct?
Exactly, especially in this episode, car accidents. But before we get to that, Tony, what's in the news?
Well, I was going to throw that to you, John. We figured we'll do a little snippet of what's in the news. Look, there's been these riots over in America, which is... It's pretty terrible, isn't it?
George Floyd, 8 minutes, a police officer in Minneapolis had his knee on his neck, Tony. Shocking.
It was close to 9.
Yeah.
And, Stacey, what I found really extraordinary is the fact that there was 3 other officers, with him. They didn't do anything to stop him.
Just stood there watching it.
Yeah.
Just stood there watching a guy being degraded, Tony, degraded. Now, the whole of America, Tony, as we all know, has gone up in flames. There are rioting in 50 states in America.
It's really sad because the message has now been lost, really, about the rights of people in general.
No, but unfortunately, the subjugation of blacks in America has been an ongoing history, Tony, and
400 years.
It's just unacceptable that in this day and age, Tony, that this can happen. It's unacceptable when you think about it.
The campaign of Black Lives Matter has actually stepped up quite well.
It has, and we've got a big...
It's all over. Yeah. It's all over social media.
Social media, yep.
Instagram.
All social media platforms.
Yeah.
I'll tell you what I find really disconcerting, but the whole movement is a great cause, but when you got thugs breaking into these small shopkeepers' places and looting and stealing, I mean, we've already got this COVID-19 virus to deal with, and a lot of people are doing it hard, and now they go back to their shops sooner or later, and guess what? They've got nothing to go back to. They've either been burnt down or looted.
Well, even New York has been looted to the point where the Rolex store on Fifth Avenue, Tony, $2.4 million worth of Rolex watches were looted.
That's bizarre. And also Macy's has been invaded. It's just absolutely insane. All right. Now, viewers, we're going to start talking about transport accidents. We've got a case of Siddell Whip and Transport Accident Commission's 2020 Court of Appeal decision. Stacey, can you give us the facts?
Yeah. This case concerned a plaintiff who sustained injury in a transport accident when the vehicle that he was driving, his tyres got caught in an overhead wires that had fallen from a tram track, and the car flipped, and he sustained an injury to his lower back. The trial judge decided that he did not sustain a serious injury as defined within the meaning of the Act, and therefore dismissed his serious injury application.
John, the Transport Accident Act and workers' compensation legislation are very similar in a lot of ways with some subtle differences, and the 40% test under work cover is a big one.
Yes.
But the thing the viewers need to understand is this. When you're dealing with a body part, the court looks at consequences. What does that mean?
Whether or not the consequences are more than marked and considerable, Tony.
Yes.
We've got a situation where in Victoria, for you to access common law damages in respect of your injuries, Tony, you have to lodge a serious injury application.
Of course.
Now, in this case, the serious injury application related to this long-term consequences of the back and spine.
Yes.
Now, this driver was driving along, Tony, and overhead wires had fallen onto the ground.
And flipped the car.
And he drove into them and flipped the car.
Okay.
So that's a pretty nasty incident, isn't it?
Of course.
Now, unfortunately, the TAC, the Transport Accident Commission, has said, no, you have not suffered an injury to your spine, to your back as such. He's taken it, he's appealed that decision to the County Court of Victoria.
Well, they've probably accepted an injury to the spine, but they haven't accepted it as being serious.
Exactly.
Within the meaning of the legislation, yes.
And Judge Misso of the County Court of Victoria has found that no, you have not suffered. Well, in this case, the driver had not suffered a serious injury of the spine, of the back. As in, Tony, the driver here has to show on the balance of probabilities that he has suffered serious consequences that are marked and considerable.
Yes, when considered in other cases similar today.
Exactly.
Now, Stacey, what's the best way to show that something's serious, that you got consequences that are serious?
Best way to show, Tony, is by describing how those injuries have affected your life.
But in particular, your capacity, how it affects your work capacity, that's
Correct.
one.
And in this particular case, Tony and John, in the affidavit by the plaintiff, he had deposed that he was promoted before the accident and he had reduced capacity. But an employer that had given evidence at the trial said that he was actually promoted after the accident.
So he's misled the court.
There was an issue of credibility there. Yes.
That's very important, isn't it, Tony?
Oh, of course. Well, look, if he hasn't lost any work post the accident, well, you've lost that ability to prove that there's a serious consequence being work.
And his tax returns showed an increase in income.
There you go. He's misleading the court.
In the end, Tony, the injured here, the plaintiff, has to show long-term impairment of the body part in question.
What Stacey just said highlights something very significant.
Credit.
These courts are very impatient, or they lack empathy in circumstances where a plaintiff doesn't say it as is, correct?
Is always seen to be misleading.
Yeah, you can't really hide.
Or exaggerating.
But more importantly, in this case here, the fact that if you're earning more or less, you can't hide it because the courts want to have a look at your tax returns. So I'm really astounded that this particular plaintiff pulled that stunt. Now, if you can't show a loss of income, obviously the other way of doing it is how it affects your day-to-day life, correct?
Yes.
Enjoyment, interaction with people. And one of the best ways to do it, John, is treatment.
Medical treatment, the medications you're taking, very important by illustrating that.
Of course.
But Tony, you're right. Credit is everything in these
100%.
cases. And I think we've talked about it before, haven't we, Tony?
Many, many times.
If the court considers that you're not an honest witness, you're not a witness of truth, they'll be very hard on you.
Oh, you'll lose every time. In fact, the Court of Appeal, Stacey and John, have effectively said that if a person's not credible, well, you can't rely on what they're saying, and effectively you just won't get them over the line.
And in this case, the Court of Appeal dismissed the appeal.
Yep. All right, let's get on to the next one. Marsh and Transport Accident Commission, 2020 Court of Appeal decision again.
Yep.
In a situation where we've got this coronavirus, they're doing a pretty good job hearing cases, aren't they?
It's all
on Zoom.
Zoom, Tony, Zoom.
Yeah.
Well,
what are the facts here, Stace?
This matter concerned a dependency claim where the son had lodged a claim with the TAC as his mother had passed away as a result of a transport accident. As per the rules of the Act, he had to satisfy that he was a full-time student in order to have an accepted claim. And VCAT and the TAC had decided that as he was not studying at the time of his mother's death, he didn't satisfy the qualifications, and therefore they dismissed his claim.
Well, they didn't pay.
They didn't pay, no.
They didn't accept the claim.
Accept the claim, no.
John, these dependency claims are pretty big because you got statutory benefits that can be pretty big, correct?
Ongoing weekly payments.
Yes.
A pension as such, plus lump sum.
And you need to be dependent.
Exactly.
That's
the key.
The key, yeah. Now, this decision's very important because in this particular case, he had taken a gap year.
Yes.
He hadn't started studying, correct?
Exactly.
And what did the court hold?
The court held that, well, he was, even though he's taken a gap year, he was enrolled. He's just taking a gap year. And the Court of Appeal have, I guess, Tony, looking at what happens in the modern age.
Yes.
As in a lot of students finish high school and guess what?
They have a break.
They have a break, which is, you know what, fair enough. And they may be enrolled, they may not be enrolled. In this case, he actually was enrolled.
Which made it easier to prove.
And enrolled as a full-time student, but he was taking a gap year. The court held that is enough to suffice that he is a full-time student.
Yes. Now, the good thing about this case also is this is what they call no fault benefit, Stacey. What's that mean?
Means that you don't need to prove fault on somebody else.
So there's statutory benefits. If you can prove you're dependent, if you can prove that you're registered to do a course, you're entitled to the statutory benefit at the rate. What rate? The rate's about $100 a week, isn't it, John? About $100 a week.
The average income.
Yeah. Now, and everyone gets it. All dependents.
Yes.
If there's 5 kids, they all get it if they're dependent. If there's a spouse that's dependent, they get it too. Correct?
Exactly, yes.
So it becomes a very valuable benefit. Now, in addition to this, we've got the fault benefits, John. So effectively, if someone caused the death of the mother, they have to weigh up whether it's more beneficial to sue for damages.
Exactly.
Because if you take damages, then it stops the statutory benefits.
It does.
Yeah.
But that lump sum benefit under the fault regime could be
big.
very big, Tony.
Yep.
Oh, yes.
And even the no-fault lump sum benefit's reasonably big. It's over 500,000, John.
Exactly.
Yeah. So, look, it's important you get lawyers' advice here because, you know, if you take a wrong turn, you can really derail or debunk any entitlements you might have. John, there's also a lot of cases we see involving cyclists.
Yes.
You know, I mean, they're critical, aren't they? Because,
exactly.
You know, what I found is that if
they are covered by the Transport Accident Act.
yes, if a car caused your injury.
Exactly.
On the other hand, Stacey, if you as a cyclist cause an injury, there's issues, there's problems. I mean, let's say you're riding a bike and you hit me. If you're not insured, I can sue you.
Correct.
And, you know, a lot of these cyclists don't take out insurance and there's an association that covers off on that.
There's the unfortunate situation, Tony, and we've come across it over the years, haven't we, whereby there's a cyclist riding along and they slip on the tram lines.
That happens a lot.
Exactly.
Yeah,
that's
that
an
happens a
issue.
lot.
That's unfortunately an issue.
You know, I had one where someone tried to avoid a car and swerved and hit the tram line and came off. We managed to get that as a car accident.
Yeah.
And they got compensation damages as well. People don't realise when you swing a door and a cyclist tries to avoid you, they're entitled, but that's a criminal offence, isn't it, Stacey?
Yes,
Now
Tony.
it is. Now it is, yeah.
And it
because,
goes down as a criminal
as you
record.
know, the paraplegics have occurred because of the dooring situation.
course. Of
And
course.
it's very dangerous.
And all jokes aside, most of us are probably guilty of swinging a door at some point in time,
Oh, yeah.
and we're very fortunate no one's very badly injured.
Oh, yes.
Stacey, anything in particular that you think these people should be aware of or careful in doing when they're handling these cases?
First thing is obviously contact your lawyers to protect your rights and just be very careful not to, I guess, expose yourself to anything unnecessarily.
And John, corroboration, you've got to go and see doctors.
You need the medical treatment. You need witnesses.
Yeah.
Tony, you need to illustrate how the injury has affected you.
That's correct. One of the things I find is that a lot of the people I see, they don't even know what's wrong with them half the times. You know, it's really surprising how I've seen a lot of plaintiffs that come to me and say, I've got a problem with my knee. I said, what's the problem? I don't know. Have you had a scan done? No. What's your doctor done? Oh, told me to wait and see.
You need appropriate medical treatment.
At some point in time, Stacey, realistically, leaving aside compensation, you as an injured person want to know the extent of your damage, correct?
Yeah, correct.
That's got to be a starting point, doesn't it, John?
You'd think so.
Yeah.
You'd think so.
I've always said to prospective plaintiffs, if I was in your situation, I'd want to know the full extent of my damage, and then I'd consider my options in terms of, you know, whether I can get damages.
Exactly.
Isn't that right?
Totally.
Now, Stacey, you said one of the key components is that they ring up the lawyer, correct? What number should they ring?
They should call us here at Carbone Lawyers at 1800 369 888.
That's a good number, isn't it, John?
Fantastic. Nice and simple. Contact us, please, for all your rights explained regarding transport accident claims.
It's amazing how many people I see that say, oh, so-and-so told me to do this, so-and-so told me to do that, and these people aren't even lawyers.
Yeah, exactly.
And in fact, sometimes I get advice from people that don't even practice in this area. That's even worse.
Even worse.
So it's critical you get the right advice.
It's a very niche specialist area, Tony.
And there's time limits, there's constraints, there's certain things you got to look, you know, you got to cover off on.
Time limits apply.
And by the way, viewers, in a transport accident, you've got to lodge a claim within 12 months. And if you don't do it within 3 years, see, the TAC got the discretion to accept it outside of 12 months up to 3 years. After 3 years, you're cactus. you cannot lodge a claim. Isn't that right?
Exactly.
And I've had people, including doctors, that have had surgeries on necks, backs, and they've tried to lodge a claim after 3 years and they couldn't. So they missed out completely. Anyway, on that note, John, thanks for coming on board as usual. Stacey, welcome aboard. This is your first time, I think.
It is.
And viewers, thanks for watching. Go to our social media platforms. Stay tuned for future episodes. And please always remember to stay safe.